Hey Legal Studs! What is the doctrine of precedent? That's the first question you should ask in your head whenever you see a SAC or exam question on precedent, and it's the one you need to provide an answer for. A one-sentence answer will do. I define precedent as a principle stating that judges must look at past decisions to determine the outcome of the case at hand. Now, let's examine the rules of precedent. Students have had a question on the rules of precedent in 3 of the last 4 VCAR exams. Before your exam, you'll need to know the rules of precedent and how to apply them to the question you're given. Let's start off by going over the basic rules of precedent. First, the ratio decidendi. This is a legal principle which translates to the reasoning behind the decision. The judge's ratio decidendi, the reasons for their decision, is what forms precedent. Not the sanction, not the remedy, nothing but the ratio decidendi. Second, we have the obiter dictum. The obiter dictum is all the additional statements made by the judge. They might be the judge's thoughts on a legal issue, not directly related to the case at hand. Courts in future cases may be persuaded by an obiter dictum statement. Next, we have binding precedent. As the name suggests, it refers to when a court has to follow a previous decision. For a precedent to be binding, the court will see if the precedent-setting case satisfies 3 criteria. Firstly, the precedent must come from a higher court. Secondly, the precedent must come from a court within the same court hierarchy. And thirdly, the facts of the precedent-setting case must be similar to the case at hand. If a precedent isn't binding, it could be persuasive. This means a court does not have to follow a previous decision, but it may still be influenced by it. Precedents from lower and same level courts within the court hierarchy, precedents from interstate or overseas, and obiter dictum statements can all be persuasive precedents. Those are the rules. Now let's apply them to some past exam questions. In 2012, students were asked to explain one reason why a precedent established in the Victorian Supreme Court, Court of Appeal, may not have to be followed in the Victorian Supreme Court Trial Division. This question asks why the precedent may not be binding. So, let's see which of the 3 criteria this case satisfies. Does the precedent come from a higher court? Yes. Does it come from within the court hierarchy? Yes. And are the facts from the precedent-setting case similar to the facts in the case at hand? We don't know, so that's our answer. The precedent may not have to be followed in the Supreme Court Trial Division because, while the precedent does come from a higher case within the same hierarchy, the facts may not be similar enough for the precedent to apply. In the 2013 exam, students were asked to outline why the Supreme Court Court of Appeal does not have to follow its previous decisions. Again, let's apply what we know to the hypothetical. We know that a precedent will only be binding if it was made in a higher court within the same hierarchy, where the facts are similar. In this instance, the precedent was created by a court on the same level. Therefore, the rules of precedent state that the Court of Appeal does not have to follow its own previous decision. When you're answering questions like these, remember that you always need to discuss the theory, as well as discussing the case at hand. It's not enough to answer the last question by saying, courts do not have to follow a decision made by a court on the same level. You need to apply it to the actual question. Thanks for watching, and happy studying!